Now call Richard Baker.
Thank you. In reforming our legal services sector in Scotland, the first principle must be access to justice, maintaining it and indeed improving it. In changing the law with a view to extending the availability of legal services, we must not unintentionally restrict access to justice for some in our society. There are important questions of how we strike the right balance in making these changes. The case for alternative business structures was first considered in the last Parliament, and we acknowledge the finding of the Office of Fair Trading does require a response from the Scottish Government and change in our legal services industry. There can be benefit to consumers if change does bring more co-location of legal and related services, a one-stop shop model, as it's been called. But there are important questions over how, in opening up the potential for new business structures, we can maintain current valued legal services. We can use this legislative process to improve access to justice and give our law firms a competitive edge. But we are not persuaded the bill as presently drafted will necessarily achieve that. There are big questions over the timing of this legislation and scope of the change. We don't argue that changes to legal services in England and Wales should simply be imported north of the border. Our system is part of an international legal services industry, but we must ensure that changes made here are right for our legal services in Scotland. It's an important point that these changes down south took place before the global banking crisis, so it will take time to see what effect they actually have there. And let us acknowledge there are genuinely and passionately held views on both sides of this argument within the law society, as both Bill Aitken and the Minister have said, particularly over independence of the profession. And I know the Minister has sought to give reassurance on some of these points. Labour members have met with those on different sides of the debate. We've benefited throughout the Stage 1 process from advice from some of those who've expressed their concerns over the proposed changes. We've also valued the input from Ian Smart, to whom Bill Aitken rightly referred, and the evidence he gave to the committee on the bill was the strongest case put in favour of the legislation. The referendum held by the Law Society on this issue showed great interest from members in this debate, as well as a divided view. I hope Parliament, and indeed ministers, now have a role in moving that debate forward. We know in favour of the bill that in challenging times economically, new investment in legal services will be welcome. We all want to see our law graduates moving on to practice in successful Scottish firms. But concerns have been raised about how access to legal services provided by small firms, often in rural areas, might be maintained if moving to alternative business structures threatens their survival. As well, as Bill Aitken said, Frank Maguire of Thompson's and others have expressed their fears over the potential for organised crime becoming involved in the ownership of firms under the proposals as they stand. The Minister referred to that issue and stated again that the regulatory regime around these reforms will be adequate to address these issues, which makes the matter of regulation vital. But the bill does allow for any number of regulators, even if the Law Society and ICAS are the two organisations expected to apply. No legal services board has been proposed as exists in England and Wales. I do have concerns still over how there will be uniformity of regulation in that context. And the idea that regulation will only cost less than £100,000, as stated in the financial memorandum, does not strike me at the moment as realistic. But we have Stage 2 to propose changes in this area and indeed in others. I am disappointed that the Cabinet Secretary did not decide to agree to the regulation of no-win, no-fee companies. That does take place down south. We will propose measures on this at Stage 2, as well as on the regulatory framework. On the vexed question of external ownership or investment, we must look to make progress. I am pleased the Minister has been meeting with those on both sides of that debate. I am pleased that those who have expressed their concerns on the bill have now brought forward constructive proposals. Members will have seen the proposal from Mike Daly of Govan Law Centre for a co-ownership model with a 75% 25% split. It is good that Parliament, the committee and indeed the Scottish Government will have a range of proposals to decide on. And these are not simple matters. They are technical and often complex. I urge ministers to ensure that there is adequate time given to ensure they are properly considered. I believe these are matters where more haste, less speed may well apply. Any of us who may have originally thought, as the convener said, that these matters would be uncontroversial and merely technical have indeed been thoroughly disavowed of that misconception. But that is because our legal services industry is important to Scotland, as is the principle of access to justice in a justice system which we rightly cherish and are proud. That is why, in proceeding with this bill today, there will need to be extensive debate over what changes will require to be made at stage 2.